Imagine this, you think following Virginia cannabis law keeps you safe, but there's a hidden twist when it comes to child custody. That surface-level clarity, it's misleading. This is where parents get caught unaware. So, you're a patient. You have a valid Virginia medical cannabis registration. You use oil or gummies legally, never in front of your child. You assume the law protects you. And legally, regarding possession? It does. But we aren't talking about possession. We are talking about custody. And in Virginia family law, the legal standard isn't whether you broke a criminal statute. It's whether the court determines you're fit. Those are two entirely different systems. And this is where the confusion starts. Here's the counterintuitive legal fact. There is a deeply held belief in Virginia that if something is legal, it cannot be used against you in a custody dispute. That is inaccurate. More accurately, it is legally insufficient. You can be in full compliance with the Virginia Cannabis Control Authority and still have a judge question your parenting time. Not because you committed a crime, but because the court operates under a best interest of the child standard. And that standard is subjective. Let's challenge a belief. If you believe that holding a valid medical card is a legal shield in family court, I want you to hold that thought. Because the statute that protects you from prosecution? It doesn't mention family law. Not once. And that silence? That's where the risk lives. Welcome to the Norfolk, Virginia Cannabis Hub. I focus specifically on Virginia cannabis law, local governance, and the gap between what is permitted and what is enforced. Today, we are not discussing whether adults should use cannabis. We are analyzing the intersection of Virginia's medical cannabis program and Title 16.1, Juvenile and Domestic Relations District Courts. Specifically, how evidence of legal use becomes admissible in custody evaluations. Here's the context. To understand why this issue exists, we have to look at 2018. Specifically, the 2018 Farm Bill. That bill flooded Virginia with hemp-derived THC products. Delta 8, Delta 10, THCO. Suddenly, impairment was no longer tied to marijuana possession. This created massive confusion for law enforcement, but also, critically, for family services evaluators. So now, a parent tests positive for THC metabolites. The other parent alleges impairment. But the parent says, it's hemp. It's legal. The court isn't a chemistry lab. The judge isn't looking at a COA. The judge is looking at behavior, testimony, and patterns. And that's where the legal clarity breaks down. Here's the legal explanation. Let's look at the statute itself. Under Section April 1, 1602 of the Virginia Code, registered patients possess an affirmative defense for possession and use of cannabis oil. That means law enforcement cannot arrest you solely for possessing your legal medication. However, family law operates under Section 20 to 124.3, the factors for determining best interests. These factors include the physical and mental health of the parents, and the willingness to cooperate in matters affecting the child. Nowhere in that statute does it say, compliance with the Virginia Cannabis Program immunizes a parent from negative consideration. So here is the gap. One system defines legality by substance. The other defines fitness by behavior. If a judge perceives that your legal use impairs your availability, your decision-making, or your co-parenting communication, that perception becomes part of the record. It is more complicated than it sounds, because the parent isn't required to be impaired. They just have to be perceived as placing cannabis above the child's routine. Let's look at how enforcement works. Who actually brings this evidence forward? It rarely starts with a police report. It almost always starts with the co-parent. One parent alleges, the other parent uses daily. They're foggy. They miss appointments. The judge then orders a custody evaluation, usually conducted by a court-appointed psychologist or social worker. This evaluator will likely request hair, urine, or blood testing. A positive result for THC doesn't prove impairment at the moment of parenting. but it does establish a pattern of use. And because Virginia law doesn't prohibit discrimination against legal cannabis users in family court, the evaluator can note that the parent is medicating daily. Let's talk about the enforcement loop. So here is the question that doesn't get asked, or rather, it gets asked, but the answer isn't clear. If a drug test comes back positive, but the parent has a registry ID, does that suppress the evidence? Legally? No. There is no suppression mechanism in family court for medical cannabis. The evidence comes in. The question becomes, what weight does the judge give it? And that depends entirely on jurisdiction. A judge in Norfolk may view a registry card as evidence of responsible medical management. A judge in a more conservative rural circuit may view the same card as evidence of dependency. This is where the uniformity of Virginia law fractures. Who this affects? Consumers. Adults who use cannabis legally, medically or under home cultivation allowances, and believe they are immune from family court scrutiny. You are not immune. You are simply not committing a crime. Patients. Specifically, registered patients using low THC oil for certified conditions. The irony here is heavy. The program designed to legitimize you does not preempt family court discretion. Employers and co-parents. This matters to the co-parent, too. If you suspect impairment, you need to understand that suspicion isn't proof. But you also need to understand that text messages, social media posts, and testimony about odor are all admissible. Local governments. Because Virginia allows localities to regulate hemp products differently, what is sold legally in a Norfolk convenience store may be indistinguishable on a toxicology screen from high-THC cannabis purchased illegally. The lab doesn't tell the judge where you bought it. Why this matters? We are looking at a collision of two progressive policies, medical cannabis access, and the presumption of shared custody. If the court begins routinely conditioning custody on cannabis abstinence, even for registered patients, it creates a coercive choice: abandon your legal medication, or risk losing parenting time. That doesn't serve the child. And it doesn't reflect legislative intent. But it is happening. Quietly. Case by case. Let's pause here, because I think many of you watching believe you understand where this is going. You think, okay, so the judge can consider it. But they won't, if it's medical. I need you to hear this clearly: the judge doesn't have to prove harm. The burden is on the cannabis-using parent to prove that their use does not negatively impact the child. That is a much harder standard to meet. Earlier I mentioned that the statutes are silent. Now let's return to why that silence functions as a legal trap. Here's a scenario. Let's build a realistic scenario. Parent A and Parent B share a 7-year-old child. They live in Hampton Roads. Parent A holds a valid medical cannabis registration for chronic pain related to an old injury. Parent A uses a low THC oil tincture at night, after the child is asleep. Parent A never drives under influence, never uses around the child, and stores the product in a locked box. Parent B, during a custody exchange, smells a faint botanical odor. Parent B documents this. Parent B requests a custody modification, alleging that Parent A is under the influence during parenting time. The judge orders a psychological evaluation. Parent A tests positive for THC metabolites. Parent A presents their registry card. Outcome A. The evaluator notes the positive test but also notes the valid registration, the locked storage, and the timing of use. The evaluator concludes the child is well cared for. The judge dismisses the motion. Outcome B. The evaluator notes the positive test. The evaluator views daily use as dependency. The evaluator recommends supervised visitation until Parent A completes a substance abuse assessment. Same facts. Same statute. Different evaluator. Different outcome. This is where the legal distinction changes everything. The difference wasn't the law, it was the interpretation of fitness. Let's close the primary loop. Earlier I said the assumption that legal equals safe is the risk. Now we see why. The resolution isn't that medical cannabis is prohibited. It isn't. The resolution is that the law allows the question to be asked. And once the question is asked, you are in a discretionary system. That discretion is the variable. Here's the new unresolved question. And this opens the next legal question, one that hasn't been litigated fully in Virginia. If a parent is ordered to cease legal medical treatment as a condition of custody, is that a violation of the Virginia Human Rights Act? Or the Americans with Disabilities Act? We don't have a definitive answer yet. Virginia courts haven't squarely addressed whether conditioning parenting time on abstinence from state legal medication constitutes discrimination. That is the emerging frontier. Here's what to watch next. In my next video, I'll examine whether employment protections for medical cannabis patients in Virginia actually hold up when termination leads to custody consequences. Because if you lose your job over a positive test, and then lose parenting time because you lost income, that's a compound consequence the statutes didn't anticipate. Here's a question to think about. If a judge can order a parent to stop taking prescribed opioids as a condition of custody, is cannabis legally distinguishable? Or are we simply seeing the extension of judicial authority over medication generally? I don't have a perfect answer. But it's a question worth discussing respectfully in the comments. Thank you for engaging with this difficult topic. My goal here is legal clarity, not advocacy. If you found this breakdown useful, please like and subscribe to support more Virginia-specific cannabis law analysis. And if there is a specific code section or local enforcement policy you want me to unpack next, drop that in the comments. I've also linked the full statutory breakdown on our community site, and I encourage you to join the Norfolk City Cannabis Community Forums to discuss how these laws interact with local court practices. That link is in the description.